This is Kenny Tan. Welcome to Real Estate License in 14 Weeks. This is episode 8 of Starting from Zero. Today we'll continue discussing Chapter 2, Ownership and Transfer. We are going to talk about community property. So what is community property? Community property is a property that is acquired during marriage. Properties that are acquired before marriage are not community property. Properties that are acquired after the marriage is over are not community property. So, for example, parents are quite often worried about giving properties to their children for fear that whenever they get married, these properties will become community property. Well, if you go by the definition of community property, if parents want to give property to their son, for example, at the time that property was acquired, if the son was not a married person, therefore it would never become a community property unless the son changes the characteristic of the property from being a separate property to a community property by adding his wife, his future wife, to the property. So only properties that are acquired during the marriage will be considered community property. There are two ways to hold community property. One is to do it with survivorship, and one is without survivorship. If it's community property with survivorship, upon the death of either spouse, there is a right of survivorship, meaning that the deceased interest does not have to go through probate in order for it to be inherited by the survivor. That's what community property with survivorship means. On the other hand, if a couple takes title to a property as community property without mention of survivorship, then it is community property with no right of survivorship. So a couple, if they want to have a right of survivorship in any properties that they own, they must either take title as joint tenants or take title as community property with right of survivorship. In terms of the benefits and advantages of couple taking title in the form of joint tenancy or community property with right of survivorship, there is actually a difference in terms of the tax benefit, which we will cover in later chapters. But for right now, you have two types, with survivorship and without survivorship. Now, there's one important point I want to bring out, which is that whenever a couple holds title to a property as community property, in other words, it is a property that is acquired during marriage. If a spouse transfers his interest in that community property to someone else without the consent of the other spouse, and whenever that happens, the spouse who did not give consent for the transfer has up to 1 year to go to court and void the transfer. That means that that spouse who did not give consent can bring the interest back into the community property. So void the transfer. Only 1 year. Okay, that's all you need to know about community property. Next, we're going to talk about will. There are essentially two types of wills that you need to be familiar with. Number one, it's called the witness will. Number two, it's called the holographic will. To illustrate the differences between these two types of will, I will give you the following scenario. A man is very sick on his hospital bed. Next to him is the nurse who has been taking care of him. So he doesn't want to leave his properties to his son because when he was ill, his son did not take care of him. Rather, it's the nurse that has been taking care of him. So he was about to die. So he called his nurse. He said, "Nurse, please come over. I'm about to die. Can you please type this on the computer and then print it out for me to sign? So you type the will for me and let me sign." So he said on his will, "I, John Smith, leave all my properties to my nurse when I die." Okay, so that is a will. then he asked the nurse to bring it to him, and he signed it. The question is that a valid will? And if it is, what kind of will it is? Well, that is not a valid will for two reasons. Number one, it's typewritten. It's not in his own writing. So in order for it to be a valid will, when it's a typewritten will like that, you will need two witnesses. In other words, the nurse have to go in the hospital and look for two nurses who can be witnesses, or two independent witnesses who can witness the man's signature before he dies. So that's called a witness will. And if that is done this way, then it is a witness will and it is a valid will. There is a second way to do it. So he's about to die and he calls his nurse over and said, "Nurse, I'm about to die. Bring me a paper and a pen." And then he uses his hand, write on a piece of paper, "I, John Smith, leave all my properties to my nurse," whatever her name is, and then he signs his name. Now, that kind of will is called a holographic will, which means that he writes the will in his own writing and he signs his name. So that is holographic will, and it is a valid will. Next, we're going to go over some definitions that are important concerning a will or situation where property is transferred from someone to another person upon the death of that person. The first one is called testator. A testator is a male person who made the will. The female person is known as testatrix. Within a will, there will be a person who's going to carry out the terms of the will, because the deceased have no way of carrying out the terms of the will. So the male person who carries out the terms of the will is known as the executor. The female person is known as the executrix. What is a devise? Devise simply, it's a verb actually. It means to transfer real property by will. We call that devise. What is devotee? Devotee is a person who receives real property by will. A codicil, it's a document that is used by the testator to change the terms of the will. Now, if a person dies without heirs, that person is an intestate. Let me add something to intestate. Intestate means a person dies without any heirs. It means that he doesn't have any relatives, such as his children, wives, parents, brothers, and sisters. Nobody could be found that could be an heir to this person. And also, he does not have a will. So if you die without heirs and without will, you are known as an intestate. What is an administrator? Administrator is a person that is appointed by the court during a probate to help administer the deceased estate. A female person is known as administratrix. So the male is administrator, female administratrix. So those are all the definitions you need to know and memorize in preparation for the DIE exam. Next, we're going to talk about probate. The only thing you need to know about probate, or at least you are required to know about probate for the purpose of preparing for the DIE exam, is that in any kind of probate sale, when a person dies, and if the property has to go through probate in order for it to be sold, that proceeding is called a probate sale. Whenever there's a probate sale, sometimes there might be agents that are involved in the sale. Now, agents would want to earn commission. So who approves the agent's commission? It is the judge or the court that approves the sale and also the agent's commission or compensation. Property can also be transferred by physical forces, such as river. You know, when a river flows from a high end to a lower end, river rarely flows in a straight line. There's usually some sort of curvature to the river. So whenever a river hits the river bank, the river is going to cause some of the soils in the riverbank to come loose. So these soils that came loose is going to be carried by the river to the downstream where the velocity becomes lower. And that's where you're going to have deposit of soils. Now, the riverbank where the soil is lost is going to result in losses to the property owner that owns the riverbank. Whereas where the soils is carried to the lower end of the stream, where the velocity slows down and there is settlement near a riverbank, that property owner that owns the riverbank is going to see a gain in the square footage or the acreage of the soils. And this happens over a long period of time. Wherever there is loss of property due to physical force, such as a river, it is what we call avulsion. And wherever there is gain of property due to accumulation of soils on the riverbank, and we call that accretion. So these are the two definitions that you need to know. Another way a property can be transferred is by way of occupancy. For example, if you own a piece of property in some remote area, such as a vacant land, and you pay no attention to it, well, the risk of that is that someone, a total stranger, might move onto your property, occupy it for 5 years or longer, or pay property taxes for the last 5 years. When that happens, you could lose your property through what we call adverse possession. So the two important elements of adverse possessions are continuous and uninterrupted possession for 5 years, and then payment of property taxes for 5 years. So that's the definition of adverse possession. Properties can also be transferred by operation of the law. What that means is that through some kind of court action or some legal reason, properties are transferred. Number one, for example, is what we call a quiet title action. When you own a piece of property, we always have the false impression that if there was something wrong with the title, let's say, for example, somebody forged your signature, have your property transferred to someone else, and you didn't find out about it through years later, and now suddenly you are living in this house and you lost the title, what can you do? Well, in order to get the title back, you have to do what we call a quiet title. A quiet title is actually a legal action to clear any cloud against your property. It's not limited to situation where you lost title. If there's something unclear about the title of your property, you can always go to court and file what we call a quiet title. Quiet title is a concept that's commonly tested in the DI exam, so it's very important you know. Next is known as partition. Previously, we mentioned that sometimes tenants in common don't get along. Whenever two tenants in common don't get along, they can actually, either one of them can go to court and force the sale of the property so that they can split up and divide out their proceeds. So we call that partition action. And next is what we call an execution sale. So what is an execution sale? If you owe the credit card company, for example, they sue you in court and get a judgment against your property. Now, in order for them to be paid out of the equity of your property, they have to go to court, get a judgment, and then apply for an execution sale. At the execution sale, anybody can go and participate in the auction and buy your property. Now, upon the sale of your property, whatever money that the sheriff receives is going to be used to pay off the debt that you owe the credit card company. We call that execution sale. Next is what we call escheat. What is escheat? Whenever a person dies intestate, in other words, the court doesn't know who to give the property to, In that case, the property goes to the state of California. So that's what escheat means. Lastly, a property can also be lost through what is known as eminent domain. So what is eminent domain? By way of example, so if a bullet train is passing through your property's current position, so that means that in order for the government to build their project, the government needs to get your property. The government can't take somebody's property without paying a fair compensation. So in order for eminent domain to happen, two requirements must be met. Number one, there must be a public use. A bullet train is public transportation, so it's considered public use. And if your property is needed to build that project, then the government will have to have an appraisal done, and then based on the appraisal, the government will give you a just compensation. Those are the two requirements for eminent domain. This is the end of episode 8. If you like my video, please click thumbs up. I will really appreciate it. If you want to receive future notification of new releases for my video, please remember to subscribe and then hit the bell. That way you will receive first notification of the video. See you next time.